Thank you very much, Andrew. I didn't realise that I was bringing you a gift, but the first time in my professional life I've ever done that to any of you. I was welcomed here this afternoon with a welcome to the Lion's Den. So that's a good start. Thank you very much. And I've sat and watched all the expressions of concentration and consternation on your faces as you were taken through how Westlaw works. I got a bird's eye view of you all observing this. It was very nice, and I'm hoping that my talk will be less concerning to you than you might expect it to be. This sounds very pompous. I have just written a book on the new Act, and in fact I was, as they say, at my publishers this afternoon, finishing off, hopefully, the last few bits and pieces of it, and it's going to be coming out towards the end of November, I am told. So like all good hosts, that's me plugging the book. The intention is that it's to be a guide to the Act, and the reason I did it was I didn't know what the Act said either, and I thought the best way to do it would be to read through it and do a book about it. There's a couple of interesting things come out of it, and I'm going to talk to you a little bit about the Act and then go on and talk a little bit more, I suppose, about the effect that it may or may not have on yourselves. I know that's what you'll really be interested in. The first thing is that the Act is now going to put me in a position where I will no longer be unique in the annals of the Scottish legal profession. I have done a jury trial in the Sheriff Court. I think they were abolished in 1980, and I did one in Greenock Sheriff Court. And it's worth telling you the story. I was conned into it. I'd not long started in practice, and I didn't think that preliminary pleas mattered terribly much. So I was persuaded to delete my preliminary pleas in a case I was defending. They're then met by a motion from the solicitors for a jury trial, which duly went ahead before, and I have to look at some of the older people here and see if we get any recognition. Sheriff Principal John Dick, as was down in Greenock. And do you know, well, you may be able to guess who the counsel was on the other side. It was Neville Shaffer. And I can remember doing that. And one of the great things about that was, and I wonder if this will happen, I spent a week, because things were done differently then, I spent a week preparing for the jury trial, reading all the rules about jury trials. And I suppose for the first time in my life, I was properly prepared for a case, because I knew how jury trials were meant to work inside out. I'm pleased to say that we won. Sheriff Principal Dick invited me into chambers when the jury was out. It's a true story. And he said, well, he didn't say well done, he just said hello. And he said, can you tell me, I'm just curious, why was it a jury trial? And I said, well, I have to confess, I got conned into it. And he said, oh, well, that's fine. He said, just don't let it happen again. And I'm not making that up. And the reason for that was, administratively, it was a nightmare in Greenock to try and organise a civil jury trial. So I may lose that distinction. If anyone else is claiming to have done it, then I'd be interested to know, but I may lose that distinction fairly soon. I want to give you a little bit again of background. I've done quite a number of talks about the Act over the last 6 months to a variety of people. And one of the things I remember, and I don't want this to sound like grumpy old men or all our yesterdays, but one of the first cases, personal injury cases I ever was involved in was back in 1977, and you do remember this, at least I think you remember the first case that you did. I didn't do it myself. It was the first and possibly the last time I ever instructed counsel in the Sheriff Court. And the counsel that I instructed was Alan Johnson. The case was heard before Sheriff Gerald Gordon, and the advocate on the other side was Andrew Lothian. And I kept the judgment. In fact, there were 4 judgments in the case. I'd forgotten it. And just to prove that I did, because I tended to keep all the judgments, only the ones I won, but That's the only one I've got. That's the original judgment from July 1977. And I'd forgotten this, but it gives you an illustration of what things were like back then. And I'm not saying they were all much better then, but when we're talking about the culture of how people are meant to litigate, the action was dismissed at debate. The judgment after the debate before Sheriff Gordon ran to 3 pages and got straight to the point. There was an appeal, and an amendment was made prior to the appeal, and the Sheriff Principal was Sheriff Charles Johnston, who some of you may know, a notorious figure, and his judgment in the appeal was 4 pages. And after the amendment, he allowed proof before answer. And I can remember this, and I'm not making it up, and I'm not exaggerating it. It was a tripping case. A milk boy tripped on a pavement, was holding a milk bottle in his hand, and cut something fairly serious in his wrist, I think, and that was his accident. And he was suing the council. Nowadays, how long do you think that proof would take? You know, anything less than 3 days and you wouldn't be trying. That's the way you might look at it. It was in Hamilton Sheriff Court, and I'm not making this up. We finished at 12:30 on the first morning. And I assumed that that's what you did. In time for lunch, and that was it. Sheriff Gordon issued a judgment, and instead of giving, and I don't criticise it, but instead of giving a narrative of the facts and all the witnesses and his view and credibility, reliability, and all the standard things that people must do now, he just basically said, let's cut to the chase. This is what this was about. This was the evidence about what it was really about, and here's my decision. And he found in favour of the defenders. And he did it in, I can't remember the precise number of pages. I've got them here, but I'll not bother counting them. But it was something like 5 or 6 pages. And the pursuers appealed, and it went to Sheriff Principal Johnston again, and he disposed of the appeal in 3 pages. And he refused the appeal. And I looked at that, and I thought, that was 1977, and I thought that was the way that litigation was normally conducted. Now, if you take that, and I'm not, again, please, I'm not saying it was all great in the old days and things are terrible now, but you look at that and you compare that with how things are done now, and you say, and you have to say, they've maybe gone a little bit wrong. And one of the things I was asked to talk about to other people was about case management and so on. And one of the points about the Act is that I have to be, I suppose, be careful what I say, but it doesn't really matter because this is my view of it. It won't work in achieving what people want it to achieve unless the culture is there, and it's the culture that counts. And that's it. That's cutting to the chase. Ignore the 136 sections of the Act. If the culture's not changing, then let's be honest, the legal profession, and I don't mean yourselves, I mean generally, will find a way of making sure that it doesn't really affect the way they want to go about doing things and the way they've always done them. So I think that's a really important thing. So far as the legal profession is concerned, it's the culture. I am now spend quite a lot of time, I suppose, writing stuff and giving talks about civil, and not so much doing it, but I still carry on doing cases. And I do know, and I'm sure you all agree, that if the case doesn't last a week, then it wasn't worth bothering about. And I don't know how much you know about what happens in England in their procedures. And I was lucky enough, I met Sir Ernest Ryder, who's fairly well known down south. I met him at something, and then I spent a bit of time with him talking to him about how they did things in England. And one of the things that he said was, and if you look at any of the English cases, and I've looked at a lot of them, it's quite apparent. They're going to impose lots of rules, and they have to impose sanctions, and the sanctions are money. That's his view. We'll make people obey the rules if we penalise them if they don't obey the rules. That's the kind of fair. This is a tremendous gloss on what he said, but that's a fair way of doing it, as opposed to dismissing actions or granting decrees or whatever. The fair way is to penalise people. And I don't know, again, how much you know about how costs work in England. I suspect that many of you do. I'm astonished at the fact that you have costs advocates and cost barristers in England, and people whose sole job is to deal with costs. And I was reading a case, and I'll give you some references to it, where the parties, this will sound horribly familiar, before the hearing, before the trial, both lodged amendments. And because there were amendments, this is literally in the last week, because there were amendments, the proof was put off, and the costs budget, which they have to have approved by the court in England, had to be revised because of the amendments. And the total amount of the costs budget referable to the amendments, and I'll not bore you with the detail of it, but it didn't seem too major, was £95,000 for the amendments only. And the judge said, I'm really quite unhappy about this. And in fact, when this way of litigating starts to cost that amount of money, then the courts are going to have to say, listen, you're not getting that money. We're not making awards of expenses if that's what you do. And I'm going to talk to you a little bit more about what they've done in England in relation to costs. If any of you have looked at the English cases where they've got the penalty, the sanctions are financial, it's staggering, absolutely staggering what they do and what things cost down there. And again, in terms of the faculty, costs, I mean, let's be honest, money is quite often what it's all about, underlying all of this. But let's just quickly have a look at the Act. The Act reminds me of the new ordinary cause rules in the Sheriff Court, which have been called the new ordinary cause rules for the last 22 years, and they're no longer the new ordinary cause rules. They brought in the options hearing, which was the hearing which was going to change the whole way in which litigation was conducted in the Sheriff Court. Did it? No, it didn't. And again, there are various changes being suggested in this Act, and they won't work unless, as I've said, there's a cultural change. Because you can put all the rules that you want. If people aren't going to comply with the culture that's underlying it, then they're not going to work. I don't want this to be overly serious. I've never been overly serious in my life. I'm not going to start now. And I don't know if any of you, again, I've looked at cases in different countries as well, and how they have coped with changing rules and so on. In England, there's a chap called Gordon Exel. Don't know if any of you have heard of him. He's a barrister in England. He's got a blog, and the blog has got details of all of the latest civil cases in England where there are decisions literally every day, and it's up to date every day. It's fantastic. You should really get a hold of it and read it. And there's usually one a day, and they contain decisions about witness statements. You know how they have that in England, where you make up what the witness has to say. Oh, sorry, no, I didn't mean that. You have witness statements instead of their evidence. There's all sorts of things about examining witnesses, about credibility, about proof of fact, and about costs. And through his blog, I picked up some rather interesting things, and I thought it might be of interest to you. I know it's entirely beside the topic that I'm supposed to speak on, but I thought it might be of interest to you to hear about Sedley's laws. Have you heard of Sedley's laws? Not too many of you, right? Well, I'll not spoil it. Sedley's laws are Sedley's laws of documents. And for those of you who are appearing in court and doing things daily, this will go down a lot better than it did to one of the talks which I did to it wasn't students, but I think it was newly qualified lawyers who unfortunately didn't get it. I think you'll get it. Sedley's laws are the laws of documents. First law, documents may be assembled in any order, provided it's not chronological, numerical, or alphabetical. It gets better. The second law, documents shall in no circumstances be paginated continuously. The third law, no two copies of any bundle shall have the same pagination. Fourth law, every document shall carry at least 3 numbers in different places. Fifth law, any important documents shall be omitted. Sixth law, at least 10% of the documents shall appear more than once in the bundle. Seventh law, as many photocopies as practicable shall be illegible, truncated, or cropped. Eighth law, at least 80% of the documents shall be irrelevant. Counsel shall refer in court to no more than 10% of the documents, but these may include as many irrelevant ones as counsel deems appropriate. Ninth law, only one side of any double-sided document shall be reproduced. The 10th law, transcription of manuscript documents shall bear as little relation as reasonably practicable to the original. And the 11th law, which strikes a special chord with me, is documents shall be held together in the absolute discretion of the solicitor assembling them by either of the following: a steel pin sharp enough to injure the reader, a staple too short to penetrate the full thickness of the bundle, tape binding so stitched that the bundle cannot be fully opened, or a ring or arch binder so damaged that the two arcs do not meet. That's Sedley's laws of documents. Now, I'm pleased to see nodding heads. We've all been there and we've all seen it and done it. It's always, yes, I know I should take the law seriously, but sometimes you can't really afford to take the law too seriously. And if you pick up from that case and from Gordon Exel's blog, another case talking about the culture of litigation from Canada, there's a judge in Canada called Joseph Quinn, and I don't know if any of you have ever heard of him. This just shows how I waste my time now, not in practice. But this is a guy who writes the funniest judgments you have ever seen. And the interesting thing is that he writes these judgments, and they are published, and he has no qualms about taking the parties to task about how they have conducted the litigation. And he's no qualms about saying things in the litigation. And I'll give you a little flavour of it, if you don't mind, before I go on to the serious bit. But if I give you a little flavour of it, just ask yourselves, could that ever be written in this country? And I'm not saying it's a good or a bad thing, but seriously, this is published as his judgment. And it was a case where someone had purchased a hearing clinic. Let's not worry too much about the detail of it. Someone had purchased a hearing clinic, and there was an argument about the price of what they had agreed for it. And this is truly what he says. And this is his judgment, which runs to like hundreds and hundreds of pages. The trial began quite unremarkably on a sunny summer day in July 2011. Storm clouds were not long in arriving, and we never saw the sun again. Counsel had estimated that the trial would take 3 weeks, and so it was given a place on the docket with that in mind. After 4 weeks, the first witness was still testifying. 6 additional days were needed to complete his evidence. In total, he sublet the witness box for 26 days. He entered the box as an articulate professional with impressive academic credentials, displaying what appeared to be a sound and comprehensive recollection of events. When he stepped down after more than 14 days of withering cross-examination, he was noticeably dazed. His credibility was reduced to existential confetti, and he even appeared to be Sorry, I find this very amusing. He even appeared to be physically shorter than when the trial began. There's a footnote to his judgment. It's peppered with footnotes, and the footnote to this is, remember, physically shorter than when the trial began. The footnote says, a variation, perhaps, of the Pinocchio effect. The case for the plaintiff was leaking oil. Brackets. At one point, I thought I saw smoke. Close brackets. And everyone who was paying attention realised that whatever damages were at issue in the trial would be swamped by the costs. After Mr. So-and-so wobbled out of the witness box, the trial lasted another money-burning 46 days, for a total of 72 days spread over 3 years. Brackets, yes, 3 years. There were 125 exhibits at the trial, which is not overly burdensome, except when one considers that exhibit number 1 consisted of 9 volumes and 561 documents, and exhibit number 90 comprised 6 volumes and 129 documents. Closing argument was in writing. They're very sophisticated in Canada. An eye-glazing, bum-numbing, disc-herniating total of 662 pages, single-spaced, medium-sized font, and heavily footnoted. Then there were the answers to dozens of written questions that I forwarded to counsel in the course of preparing these reasons. The trial was like a physical deformity that one eventually accepts as a permanent condition. And there's some good news for the advocates. Yet, despite everything, I will recall the experience fondly because of the unrelenting civility of counsel. Footnote, some counsel can fake civility for the first few days of a trial, but soon succumb to the strains of insincerity. The civility here was genuine. So he goes on. This goes on for pages. It is really, if you have an opportunity, if anyone wants to know, I can give you the details of it, and you can get a full copy of it. And it's fantastic. But also it makes you look back and say, how do we conduct litigation? How did they conducted this litigation? He makes fun of everything. It's really hilarious. And that was a serious dispute. And at the end of that hearing, he awarded the plaintiff $423. And that was it. So when you look at that and then we come back and say, right, okay, where are we now? We've seen what happens in England. There's a nice illustration of Canada. And one of the other features of the Act, and again, I don't know how much you've looked at it, we are now in the technological age. And I think one might expect the Act to say, right, okay, so where's the technology? There's one reference to technology in the Act. I'm pleased to say I can't remember which section it is, but there's one reference to it. And if you buy the book, you'll see I identify it. And it seems to me, again, from some inquiries I've made, that we haven't embraced the technology at all as yet. And when you compare this with, for example, I was looking at an American case, which I'll tell you about in a little moment, where I went online to see if I could find out anything about the case, and it took me 30 seconds to download the summons in the case from the court, just on the internet. And I always compare that with how long it takes you to get an opportunity to see something, a writ, for example, in the Sheriff Clerk's office in Glasgow. It usually takes about 3 weeks, and you have to make an appointment. And although there's a lot of talk about technology and bringing things up to date in technology, unfortunately the Act hasn't really gone very far. And I said very unkindly at one time that now our bow to technology is that the Scottish Court Service have decided to buy a computer that works, and we'll take it from there. So it seems to me that we've not really moved very, very far with that. let me go on then to speak. I think I was told at one stage, is this an opportunity or a threat? That was the idea. Was the Act an opportunity or a threat? It very much depends on how things actually turn out, as opposed to what the Act says is perhaps expected. And the one thing I think everyone probably realises is this is really about personal injury cases. Bottom line is, it's about how you handle personal injury cases. And so far as the faculty is concerned, I'm sure it's about the extent to which you will continue to be instructed in personal injury cases. I can't claim any insider knowledge of that. There was a time when I used to give lots of instructions in personal injury cases. I don't do that anymore. You know and I know that the people who give the lots of instructions in personal injury cases will, to some extent, be calling the shots. And they will make decisions, presumably, about how they want to pursue a personal injury case. And that's the reality of the position. I remember remarking a few years ago to some friends I had at the bar, I think there were two of them, that they would have to see themselves as part of that interest group, if you like, and appreciate that there are commercial realities and that people will want them to comply with the commercial realities. And the reality, again, is if someone's going to give you 100 instructions, then you'd be happy to take them, and I would imagine you'd be happy to have some discussion with them about the terms in which you'll take them, because they'll want to have discussions with you about that. And I do know that insurers are keen on doing that sort of thing as well. I mean, there's nothing clever about that, and I'm sure that you all appreciate it. But it's the personal injury cases that are the thing which I think one ought to look at. And in doing that, I tried this exercise of how are personal injury cases going to operate from now on. I don't have a great crystal ball, and unfortunately all I can do is pose some questions for you. Has anyone heard of Eugenie Bouchard? And she is a tennis player. Yeah, she's a tennis player, right. You're the first person who's actually knew who she was. She's a tennis player, and she had an accident after the US Women's Open. After playing a game, she went into the dressing room and she slipped on something that was on the floor, and she hit her head on a locker. And according to the summons, and I've seen it and I've got a copy of it here, she went from being a top-class tennis player to somebody who may never play tennis again. And her claim was that someone had left some substance lying on the dressing room floor, and that was why she had her accident. And of course, within, I think it was 2.5 weeks of the accident, proceedings were raised in, where was it again? The United States District Court in the Eastern District of New York. And that's the summons I downloaded. I read about it and I thought, I wonder what happened in that. And I got the 10-page summons. It's rather interesting to watch how the Americans set it out and how they use really archaic language in their system. It's really quite strange, considering many other things, but they're way behind the times in the language. Anyway, she demanded a trial by jury, and she had various allegations about how she would never play tennis again, etc., etc. And I kind of took that case and said, right, imagine that instead of it being Eugenie Bouchard, it was somebody who was not a bad tennis player in Scotland, but not very brilliant, and had had that kind of accident at, let's say, the SEC in Glasgow, and you are instructed to pursue her personal injury claim. So the first thing is you're going to have to say, right, what's the value of her claim? Is it realistic to think that she would, Mrs. McGlumpha, as we say, Senga McGlumpha, would have been a big money winner in the Scottish tennis circuit? Now, the first thing you have to do is say, right, okay, well, I'll raise that in the Court of Session, because it's probably worth over £100,000 if she has this potential loss of earnings in the future. Now, The Act, I suspect that you'll all be aware of this, gives the Court of Session the power to say, we don't think that's worth £100,000, and we're going to send it down to the Sheriff Court. So there's a power in the court to do that. Let's just assume that you didn't think it was going to be £100,000, but it's going to be about £50,000 or £60,000. So as a solicitor, where would I raise that action? And my choices after the Act are, I can raise it in the Sheriff Court, I can raise it as a personal injury type action in the Sheriff Court, or I could raise it in the new Sheriff Personal Injury Court, which I have decided to call ASPIC, ASSPIC, because they called it ASPIC. I don't know if there's any view here about what it should be called, but anyway, ASPIC. You could raise it in ASPIC. But I can make out a case for saying, well, why don't I do it in the Sheriff Court? But you know what? She's got a head injury. It might be a wee bit difficult to figure out. I think I'll get counsel in the Sheriff Court. And I think I'll make a motion for sanction for counsel at the outset of the action, which I can do now. And I'll see where that takes me. So I make a motion for sanction for counsel, and it's refused. Let's just say that happens. What can I do about that? Unless I get leave to appeal against it, I can't do anything. So if a sheriff decides, for example, that kind of action, it's not going to be one in which I'll grant sanction for counsel, then there may be very little that anyone can do about it. What if that becomes a norm? I'm not here to worry you about it, I'm just talking my way through this. If that becomes a norm, does that mean that everyone will be looking at this and saying, so you don't get sanction for counsel for that kind of case that's worth £50,000 or £60,000? Will that become a norm? Put it the other way around. What if you did get sanction for counsel on the basis that it's a personal injury case? There could be problems. There might be issues about the relationship between the accident and our injury and what a head injury means. Yes, I think there's enough in this to give sanction for counsel. What happens then if people say, so that kind of case, if there's a complication, you can get sanction for counsel? So the court could decide that, and there may again be no opportunity to appeal it. If the court grants leave to appeal, that would be an appeal to the Sheriff Appeal Court. That's what the Act would now permit. Okay? So it goes to the Sheriff Appeal Court, where a decision could be taken by one sheriff or three or more sheriffs. And again, there's no point in getting into the detail of it. You see it in the Act. It could be one or three or more sheriffs. One sheriff, if they decide that it's not the most critical thing in the world, and it could be heard by one sheriff, and the court can comprise one sheriff. 3 sheriffs would be the norm. More than 3 sheriffs if it's a matter of some importance. And just to add to that, the Sheriff Appeal Court can say this is so important that we're going to body swear, well, no, sorry, I shouldn't say that, should I? We're going to pass it on to the inner house because it's so important. So they can actually decide to pass it on to the inner house. So the way I look at that, and I'm not criticising it, I'm just observing it, is that what will happen, never mind what the Act says, that in practice, my estimate of it is that the courts will decide what the appropriate level might be and whether you get sanctioned for counsel at this level or that level. That's my kind of feeling about it. I've got no crystal ball, and I'm not claiming any particular expertise in this because you can't have it. But you will find the courts can decide it. And then, although the level at which the case can be heard is determined by the Act, which says complexity, difficulty, and so on and so forth, the decision about sanction for counsel in it is entirely discretionary. And if you look at, again, what the Act says, and if you compare with what the Taylor report says, the Taylor review and expenses about sanction for council, and I've looked at it and I've studied it fairly closely, there is very little difference in the Act about the basis upon which sanction for council will be granted from the way it has always been. And in the Taylor report they said the feeling was, and I'm not sure if this is right, no doubt people can say otherwise, that the court was relatively liberal about granting sanction for council, and that there was no consistent approach, but by and large they tended to grant sanction for council. And all that the Act said was there was an additional factor, there is an additional factor of reasonableness, which I don't think adds anything to the discretionary decision, and equality of arms. And the way I read that is, if the other side have got counsel, then you should grant me sanction, because it's not fair for me to be against counsel on the other side, which frankly was my understanding of the way it would tend to work in any event. So in practical terms, and I may be completely wrong about this, in practical terms it seems to me that the question of sanction for counsel, which is close to your hearts, at whatever level, Sheriff Court or the All Scotland Sheriff Personal Injury Court, is eventually going to be decided by the courts themselves, using criteria which, frankly, are not much different from the criteria that they've used until now. And I am curious to see whether, on the one hand, let's say, we have the Sheriff Appeal Court saying, here is how we see litigation being conducted, personal injury litigation being conducted, and we see counsel being required in all but the most straightforward personal injury cases, or laying down some precedent which says, no, you can't get it for this, that wasn't the plan. Now, of course, they won't put it that way. It will be part of their discretion, it will be part of the interests of justice and so on and so forth. So that's one possibility, and the other possibility is that the Inner House will say, if an appeal finds its way to them about the appropriate level of the court, or decisions about whether it should be moved up or down the hierarchy, whether they'll say, here's what we think the position is. And there's nothing in the Act, I think, that would fetter the ability of either levels of court to do that sort of thing. So I suppose answering the question, is it an opportunity or a threat, you come up with a classic lawyer's answer, which is that, it depends, actually. And it seems to me, with all respect to those concerned, that whilst in England, in America and Canada, judges can take a view about what litigation should be about, what it should cost, how people should litigate proportionately, in Scotland there's a kind of disinclination on the part of the judiciary to say this is the way that litigation should be conducted. The idea, again, with all due respect, of a judge in the Court of Session getting his sleeves up and saying, and what is your budget for this case, Mr. Hennessy? And I want to see that. Now, do you really need that? Is that not very expensive? I want to control your costs, which is what they do in England. There will not be a queue of judges wanting to come and do that. That's my view about it. And I don't quite know how that will resolve itself. Because if they bring in the rules and they say in order to get people to obey them, there's got to be monetary sanctions, then someone's got to impose the sanctions, and someone has to take the view that, no, that's not the level of costs at which this litigation should be conducted. I'm not sure our judiciary want to know about that. Maybe they'll have no choice, but that's something that I see happening. So I suppose I've managed to avoid the question reasonably well, avoid giving you any answer, but hopefully stimulate some thought about it. And my prediction of how it might go may be completely wrong. It's completely guesswork. And one of the disappointing but not too surprising things I've noticed is that I've spoken to various people about it. 6 months ago, there were people who are, let us say, sitting on benches somewhere saying, so what is this new Act thing? What are we supposed to do? And there's still that feeling that people are not going to tune into this until they're in the middle of a case and someone says, what about rule such and such, Mr. Bloggs? Oh, what, have they changed those? And that's a slight concern that the profession haven't quite caught up on it. But of course, I can finish by saying there's a book coming out on it which would actually keep them well up to date. Anyway, I hope that was of some interest to you. Thank you very much.